Now, many people think that the language in insurance policies is standard, and in some ways it is. Insurance companies look to see what their competition is doing. So yes, insurance language becomes relatively uniform over time, but it's a moving target, and it's not so uniform that you can't find a carrier to sell different kinds of products. The interpretation of insurance policies is of the utmost importance both to the insurance company and to the policyholders. Unusual things happen in this world, and sometimes the parties had not thought through exactly what would occur with respect to their insurance when something strange occurs. Now, what happens, for example, if your furnace leaks and somebody on the third floor is sickened by the fumes? Or what happens if you're a farmer and you hire a truck and the back of the truck contains some metal shards, and the cattle in that truck eat the metal shards? Was your cattle damaged by pollution to that truck? Were the secretaries who were sickened by pollution within the building? These are the kinds of issues that occur because we use the word pollution somewhat flexibly. So we all know the prototypical situation of pollution. You can't dump poisoned blood into the Hudson River. You can't emit poisonous fumes into the environment. But in other situations, we're really not quite sure. Many years ago, insurance policies were written in some kind of strange legalese that was very difficult to understand. Now, the courts, knowing that the insurance companies wrote the language, would apply a doctrine called contra proferentum, which says that ambiguities in an insurance policy are resolved in favor of the policyholder. Between that doctrine and a plain language movement in which consumer documents are being drafted more and more in language that people can understand, the language of insurance policies has actually gotten simpler over the past several decades. The result has been that the courts have been more sympathetic with the language being used by the insurance carriers and have been more comfortable giving the policies a literal interpretation. And at least within American courts, we're dealing with a period of time in which courts seem to be more interested in literal language and less interested in divining the intent of the parties. So the trend right now in the interpretation of insurance policies is something that the insurance companies will like, because it tends to respect the language that was used in the policy more than, say, 40 years ago.